Okay. Is my screen visible?
Yes, ma'am.
Thanks. Uh, okay. So, good evening, everybody. This is your task three for the November drafting batch. We're going to be learning how to draft a regular bill. First off, just to give you a brief overview of what a bail is, a bail refers to a legal process that allows a person who has been arrested or detained by the police or other law enforcement authorities to be released from custody temporarily under certain conditions while their criminal case is pending trial. Bail serves as a mechanism to protect the rights and liberties of individuals, ensuring that they are not held in detention for an extended period without a fair trial. The concept of bail is governed by the Code of Criminal Procedure 1973, also known as CRPC in India. So, bail is basically a process or a legal process which basically allows a person um, to be released temporarily if he has been arrested or if he's been kept on custody by the police or any other law enforcement authorities. Now, there are certain conditions which need to be followed. Um, and it basically, so as we all know, 24 hours. So any individual arrested or detained must be produced before the magistrate within 24 hours. So if that does not happen, the individual can apply for a bail saying that the police have not done their work efficiently. I need a bail. I have been in the, I have, even if it crosses a minute more than 24 hours, the individual can apply for a bail and the individual will definitely get a bail because it is on the police that, the individual has not been produced before the magistrate. So, a fair trial is every person's basic right. People who are detained, people who are actually kept in custody, it is a basic right for all of those people to have a fair trial. Now, a fair trial includes being produced before the magistrate, um, having reasoned decision. If the court gives any decision, it must be backed by reason. Thirdly, there must be so there is 24 hours before the magistrate. There is a reason the decision. They must be given adequate opportunity to speak and they must be heard. And it must not be that only one person is speaking and the other person is not even, given a chance to speak. Another thing that can be kept in mind is that principles of natural justice need to be followed. So all of those are all included in the concept of fair trial. And bail is one of the legal processes which is part of the fair trial for people who have been kept in jail or in custody for a longer period of time than what is prescribed, unless the police have taken special permission from the magistrate saying that okay, there is a little bit investigation pending and we will produce him by the end of 2 or 3 days, and depending on the decision of the magistrate, again, that also can be changed and altered. Moving on. Um, Now, there are certain key points regarding bail in India. Now, as I've already mentioned, bail is a it's a temporary release. It is not a permanent release. It is only for a, a less number of days or for a few hours for that matter. And it's always and the bail can always be taken back and the person can be brought into custody if he violates any of the provisions of the bail or any of the provisions of the application of the bail that he himself through his advocate has put forth before the court. Now, moving on, there is presumption of innocence.
यार अब पापा हाथ में सबको लिया नहीं, मेरे को लिया नहीं, पापा फाइट खत्म हो गई।
Shubham,
मुंह तो लगा हुआ है,
please mute
कढ़ाई से
yourself.
तो मनवा नहीं भरता है। तो लगता है हर दिन मुझे वो टट्टी मार जाते हैं।
Okay. Um, Guys, please keep your mics on mute. I do not want to hear what's going on in the background, and especially if it's what just happened. I do not want to hear it. Um, Anywho, so okay, so presumption of innocence is something which India follows as a principle, as the Magna Carta, or as the crux of any kind of criminal proceedings. It is said that a criminal is innocent until he is proven guilty. And we work on the principles of, and innocence is something which is every human's basic right, is what India thinks. But there are many other countries which state that um, guilt, presumption of guilt. So another contradiction to the presumption of innocence is presumption of guilt, wherein the accused is uh, presumed to be guilty until he is proven innocent. Okay, and bail can be okay. All right. So there are two kinds of offenses, bailable and non-bailable. Now, bail is given on certain bailable offenses, on most bailable offenses, and on certain non-bailable offenses. I will give you examples in the upcoming slide. Again, there are certain conditions that need to be followed before the courts can grant a bail. There's another kind of bail which is known as anticipatory bail. Anticipatory bail is basically, that bail before even arrest. So if a person thinks that he is about to be arrested, he can always apply for an anticipatory bail. An anticipatory bail is uh, that the person anticipates that he's about to get arrested, and it is under section 438 of CRPC. Um, Okay, and anticipatory bail is again granted with certain conditions which the accused must agree to. Only then is he granted anticipatory bail. Then there is judicial discretion. Now, the decision to grant or to not grant a bail is upon the magistrate or is upon the court where the bail application is being filed. Now, the court considers multitude of factors, including how serious the offense was, the so any bail application needs to be supported by evidence. Now it also looks at the strength of the evidence. It looks at the accused's criminal history, and also looks at the fact as to how likely the accused might run away or might he might be on the go or he might be on the run. So that is something that the court keeps in mind before they grant or not grant an anticipatory bail. Sorry, any kind of bail. Then there is cancellation of bail. Now, bail can be cancelled if the accused violates conditions mentioned in the bail, um, or certain conditions are violated which are imposed by the court to the accused, and if it interferes with investigation of the police officers, or if it engages in any, or if he or she engages in any misconduct, the bail can be withdrawn and can be cancelled, and they can be brought back into custody. Now, appeal and revision, both the accused and the prosecution have the right to appeal or seek revision of the bail in a higher court, and if they are dissatisfied with the decision. Now, bail applications are usually presented before the Sessions Court, which is just below the High Court. So those courts are usually where bail applications are presented, and if the accused or the prosecution feels that the judiciary has failed in giving a fair decision, it can either ask for revising of the bail, which means that it will ask the court at which the bail is granted or not granted to look over it again, to look at the conditions and to look at the evidence again, because they have certain evidence which they think might deter the decision of the court. And appeal, as we already know, is going on the higher bench. Now, for example, um, if the Sessions Court decision is not favorable to someone and they are sure that the court might reverse the decision, they can go on appeal. Appeal is basically to the higher court, and where there is Sessions Court, the court above it is the High Court. Now, there are in the High Court also, if the decision of the High Court is again not something which is favorable, then you need to revise it first, and then you can appeal in the Supreme Court. Usually, bail matters don't go until the Supreme Court unless it's of exceptional circumstance. Um, Now, bail in India basically is a legal mechanism that ensures. One second. Okay. So, bail in India is a legal mechanism that ensures the accused right to liberty and a fair trial while also considering the interests of justice and the protection of society. It is an important aspect of the criminal justice system, and it balances the rights of the accused and with the need to maintain law and order. So both of these are balanced depending on where, what, and how, and the circumstances and the conditions and the presumptions, etc. Now there are about as of how much I know, there are about seven types of bail. Now a regular bail is grant in a bailable offense is granted as a matter of right for offenses that are classified as bailable. Now in the Criminal Procedure Code, in the BEAR Act, towards the end, you have something known as schedules. In one of those schedules, you have offenses which are classified as bailable and offenses which are classified as non-bailable. Now, those bailable offenses, um, so the bail is granted in bailable offenses as a matter of right. It means that if I have, if my rights have been violated in the offense that I am accused of is a bailable offense, I can demand for a bail. I have a right to get a bail, and these are less serious offenses, and the accused has right to be released on bail upon arrest. Now, the accused must provide a personal bond, number one, and sureties as per the court order. Now, certain examples of bailable offenses are traffic violations, minor criminal offenses like, let's say I'm not advocating that robbery is a bad thing or stealing someone something is a good thing, sorry. But if you've stolen just 10 rupees, it is a bailable offense. It is not a very serious offense, it's just 10 rupees, and you can always go and get it back, or you can return it and you can go out on bail and do your work. Moving on, regular bail is a non-bailable offense. Again, non-bailable offenses are mentioned in one of the schedules to the Criminal Procedure Code. Now, the accused does not have an automatic right to bail in non-bailable offenses, but in such cases, the accused can apply for regular bail to the court having jurisdiction over the particular matter. Now, bail for non-bailable offenses is granted at the discretion of the court, and the court may or may not impose conditions as it deems fit. That is regular bail in a non-bailable offense. Moving on, you have anticipatory bail. Now, anticipatory bail is a type of pre-arrest bail that individuals can seek when they anticipate being arrested for a non-bailable offense. Anticipatory bail is only granted for a non-bailable offense. It cannot be granted for a bailable offense. Now, the purpose of including this kind of bail in our criminal enforcement is to prevent unnecessary harassment and arrest by law enforcement agencies. Now, there are a lot of times where people have been arrested just because the police authorities have certain kind of vendetta against them, have certain personal enmity against them. So, just so that that doesn't happen, you have something known as anticipatory bail. And the court may grant anticipatory bail with or without conditions to ensure cooperation with the investigation. Cooperation with the investigation is the main motto of granting anticipatory bail, and and if the court sees that there are no other um, conditions that need to be met, it can grant anticipatory bail on the condition that they will not hinder the investigation process. Um, Moving on, there's something known as interim bail. Now, interim bail is a temporary release from custody granted by the court when regular bail is not immediately available. It is usually granted for a short period, and the accused may later seek regular bail. Interim bail is often provided in exceptional circumstances and are subject to conditions. Now, there are certain times where regular bail applications take a long time. In that circumstance, you have interim bail, wherein it is a it like in any of your petitions, you have something known as interim relief, which means immediate relief. So in this case, immediate bail is something which is also available. So that is called as interim bail. Now there is default bail. Default bail is granted when the accused is not tried within a stipulated period. Now, 24 hours need to be produced before the magistrate. If it's not been done, default bail is granted. Then you have admission of bail. Now, this is in case of juveniles and special bail in case of other specific laws. These bails are again, they need to be applied for and then they need to be given, but they can be categorized as a different kind of bail also. Um, Moving on. It is important to note that, keep this in mind, that bail is not an absolute right, especially in cases of non-bailable offenses. The court will consider various factors like nature and seriousness of offense, strength of evidence, accused criminal history, all of that is kept in mind, and then a bail is granted. So these are the kinds of bail. The meeting is just about to end. I will be resending you the link in about 10 minutes.